And today we have another interesting topic to look at, like so the Nigerian Police Force Established Act 2020 implications on human rights. That is the topic of discussion for today. And to discuss this, we have Olaita Eyowawi, consultant solicitor, Simeon Bethel Solicitors, London, United Kingdom. You're welcome, sir. We also have Mazi Afam Osigwe. He is a senior partner at Law Fort and former General Secretary, Nigerian Bar Association. You're welcome also. We also have KUNLE EDUN. He is a human rights activist, welfare secretary, Nigerian Bar Association, and senior partner, Tri-Lex Partners, LP, Warri, Delta State, Nigeria. You're welcome.
Thank you very much.
Finally, on our list, we've got Sylvester Udemezue. He is legal practitioner and lecturer, Nigerian Law School.
Thank you very much. Without wasting time, we have KUNLE EDUN, please. We know you have a lot to say on this legislation. Are you able to make your presentation at this point?
Thank you very much. I think we just succeeded in wasting our time by going through and enacting this Nigeria Police Act 2020. It was an unnecessary legislation, like what my very good friend Afam said, because many of the provisions of this said law are mostly repetitions of the provisions of the Administrative Criminal Justice Act, and of course the domesticated versions in various states, like in Delta states. Now, I want to pick one or two areas of this new law that I feel strongly that were actually brought in mischievously. Now, we are talking about, if we go to the provision of section 35.2, section 32 of the said law, it talks about when suspects can be investigated, arrested, and dealt with. That is the word that the law, this section mentioned. It said, dealt with. How can you deal with a suspect? Are we seeing a military era? And by the way, it is wrong to itemize it that the procedure for dealing with a suspect is you start with investigation, then arrest. No, it is wrong. That is not the norm. The norm is when a suspect, when you feel strongly that a suspect has committed an offense, there's a reasonable ground for the person to have been arrested. You invite the suspect, you investigate thoroughly, and if there is a prima facie evidence that an offense has been committed, then you don't have a basis to arrest him. But that is not what the provision of section 32.1 of the Act is saying. So that section 32.1, it has now further come into legislate and give further approval to the procedure of the police, where they now do more of arrest-driven investigation instead of intelligence-driven investigation. And also, there is also, of course, one novel provision, which is not really novel, because also in the AJA and ACJ of various states, where the magistrate within some ministerial districts had the authority to now visit detention centers within their ministerial district. That is good, but it's nothing new. It is also in ACJ and ACJ of various states. And every month, a periodic report is expected to be produced after such visits. Now, there is a lacuna there. That provision talks more about knowing the number of detainees in such detention centers. What about properties that have been seized by the police? Because I was in court day for yesterday, on Friday. There was a case where policeman arrested somebody, and seized the person's vehicle. The vehicle had nothing in connection with the alleged offense. Now, the person was charged to court. The court made an order that the vehicle be produced. Therefore, said I was in court, the vehicle was not produced. Should a magistrate not go to the detention center and the record shows that this person, my client, has been released, what about the vehicle that is still in the custody of the police? So that is very, very lacuna, because the police only talks more about detainees. It didn't mention anything about property seized. So it would have been good if property seized and still in the custody of the police are also itemized in the monthly report. Because we know as a fact that many of the vehicles that are seized, many of these policemen, they convert same to their personal use. And that is very, very criminal. Now, there's also this other aspect of the law that I am very, very worried about. The aspect talks more about the custody of of detainees. We all know that the cells, the detention centers are smelling. They are dingy. No human being can actually live there for even 1 hour. The person will either faint or collapse or die. Now, the problem now is the Police Act now talks about recording of statements. The recording of statements in this wise, in that same dirty and dingy condition, it states that, of course, a relation of the suspect would have to be there. A relation or any person would have to be there. But it is not made in mandatory terms. And that is a problem. The same problem that Aja brought in, because Aja has not even helped. Aja made it optional. In fact, judicial decisions by various courts is that it is not even mandatory for a suspect lawyer to be present. I said, my lord, that is wrong. Because the intention of the law is that before a suspect makes a statement, he must be availed the opportunity of having legal advice. And his counsel must be there. But the provision of the new Police Act has made it optional, which has not really changed anything. Now, further, we are also talking about the issue of, in fact, Section 44 of the Act is a disaster. Why am I saying so? It made the requirement of visual and audio recording to be optional also. It shouldn't be. So, and let's ask ourselves, have we really moved away from the norm of collecting, extracting confessional statement from suspect accused person? No, because making the statement without the presence of your lawyer, making the statement with or without audio or visual aids, and now be made optional, not mandatory, certainly nothing new has happened. Nothing new has come in. So there is no innovation so far that I have seen in the Police Act. Of course, we are aware of a particular provision in the Police Act which states that suspects must not be arrested by proxy. Good, that is nothing new. The Constitution has already taken care of that. And of course, after that suspect also, when you are arresting a suspect, you must not base such arrest on the color of the suspect, the age of the suspect. You know, a lot of Yahoo boys have been arrested nowadays because of because of their hairdo, the way they dress. Of course, the Nigerian Police Act 2020 has taken care of that, that a person must not be arrested on such basis. But is that new? That is not new. The Constitution of the Federal Republic of Nigeria, Chapter 4, has already taken care of all this. So the question now is, was there proper consultation? I believe there was none. The NBA wasn't really aware of this. And I also know that experts in criminology and criminal law were also not consulted. That is why we are having a lot of issues with the new Police Act. But no matter how bad it is, I think we must also give the Police Act some kudos. Now, there is a novel provision in the Police Act which has to do with the creation of a group of persons. They call them special constables. That is any person in the community, like I myself, for example, I can be recommended to be appointed as a special constable, and I think that is good. Of course, I will not be part of the regular police force, but for the purpose of oversighting the various policemen and their functions, probably going to the detention centers, special constables are now to be appointed. I think that is one innovation that, to the best of my knowledge, that Aja did not bring in. The Constitution did not really provide, but this new Police Act has made provision for it. So by and large, we can say very well that this new Police Act has not really said anything new, has not brought anything new to the table. And we believe that probably, particularly those sections I mentioned about taking of statements, visual aids, and audio aids when suspect statements have been taken, they ought to be made mandatory. But nevertheless, it is still left to the judiciary. I don't want to put all the blames at the doorstep of the police. Our courts needs to be very, very active and proactive in the interpretation of these sections. I know very well of a case in Lagos that emanated from the Court of Appeal, where the Court of Appeal held that, notwithstanding the fact that May was used in that particular provision with regards to whether the suspect's lawyer or relation or any other person can be there when he's making a statement, that a collective reading of that provision indicates that it is mandatory. That is a proactive legislation. But I am afraid that most of the high courts have refused to follow that decision. They still strongly see it that no, it is optional, that it can never be mandatory. And in that very wise, we have a lot of persons that are in the detention right now, in the cells, in the prisons, that were convicted solely on the basis of confessional statements. And this also creates a further problem for the police and the judiciary, and of course, the society at large. Because when you rely so much on confessional statements to convict an accused person or a defender, as the case may be, then you are preventing the police from interrogating the case very well, from going for further intelligence, for intelligence-driven investigation. That is what drives the world nowadays. That is what drives investigation. Intelligence. Thank God that SARS has been scrapped, because I keep on asking myself, if the police has been doing proper intelligence gathering, before the offense is even committed, they already know. They already know. So this the new Nigeria Police Act has not really made any difference. Has not brought anything new that I've seen. And I think I agree with the previous speakers with regards to the position, particularly that of Alpha Musigwe. I want to pause for now.